Good morning. Today we are going to discuss the topic act of child. That is, what is the position of a child under BNS or under criminal law. Section 20 and section 21, that these two sections relate with the position of the child. Dolly in capax means a child who is not having sufficient maturity. Section 20 states that nothing is an offense which is done by a child below 7 years of age. Means if a child below 7 years of age does anything which we call as a crime, it will not be a crime for the child because he is not having that sufficient maturity. This section 20 is absolute immunity. Law considers that a child below 7 years of age lacks complete maturity, therefore they are not liable. So section 20 is absolute immunity, you can say. It is complete exemption for a child below 7 years of age. The other section is section 21, which states an act of a child in between 7 to 12. Means a child above 7 years but below 12 years. If such a child does an offense, does a crime, then it will not be a crime if here means here there is a qualified immunity. If the child lacks maturity of understanding and because of which the child does not know the nature of the act or the consequences of the act. Means a child below 7 years is absolutely immune. However, a child above 7 and below 12 is qualifiedly immune, means a child who does not know the nature of the offense, the consequences of that act, then only he will be exempted. But if he knows that, then he will be liable. The child will be liable. So, section 20 tells about a child below 7 years of age, absolute immunity, nothing is an offense, and section 21 states about a child above 7 years but below 12 years. If the child, because of immaturity of understanding, is not knowing the nature and the consequences of the act which he is doing, then only he will be immune, he will be exempted, or whatever he has done, that will be nothing called as a offense. The child will be considered to be dolly in capax. Now here, as per section 21, sometimes the child is liable, while sometimes the child is not liable. So we have to see this as per the circumstances of the case. The facts of the case are going to tell whether the child is lacking maturity or not. Like what that child has done, whether intention is there, whether maturity of understanding is there or not, we have to see. A girl was catched, some 10 or 12 years girl, 10 or 11 years, we'll take an example. 11 years girl was catched for stealing a silver button. But it is quite natural that when a child sees anything shining, that child is going to take it. And then what that girl had done, that girl had given that silver button to her mother. Now it is also quite natural that a child, when he finds certain things, that child will give it to their parents or any of the relatives. Therefore the child was exempted because she was not having the knowledge that what the silver button is, whether it is of silver or something. She was not knowing anything. She was only knowing it that something shiny she has got. So she took it. Therefore the child was not liable. So from the facts of the case, we have to consider whether the child knows the nature of the act or the consequences of the act or consequences of their conduct. Then only they can be exempted. This is section 20 and section 21 telling about the position of a child in criminal law. Nothing is an offense. Only if, as per 20, the child is below 7 years, and as per 21, child above 7 but below 21 but is lacking maturity. Got it? Now the next section is section 22 telling about unsoundness or insanity. A person who is suffering from unsoundness of mind, he will be exempted in crime. It will not be a crime because he is not understanding anything. He is not knowing that whatever he is doing is wrong or right, or what are the consequences. He does not know anything because he is lacking that maturity because of unsoundness of mind. Therefore, unsoundness of mind is also a very good defense. Here we are having an important case which we call at, or which has fixed certain rules for unsoundness, and that is M. Norton's case, or it is called as Macnaghten's case also. Okay, now here what Macnaghten has done, he has killed one Drummond. Drummond is secretary of Robert Peel. Robert Peel was the Prime Minister of Britain. What Macnaghten thought, that he wanted to kill Robert Peel, but he, under mistake, he considered Drummond as Robert Peel and he killed Drummond. And after that, he took the defense of insanity, and his insanity was proved also, and he was found not guilty. Therefore, from Macnaghten's case, we have considered certain rules which are called as Macnaghten's rules. Now, many states or many criminal laws have accepted that Macnaghten rules, and what those rules are, that every person is presumed to be sane. Therefore, insanity is to be proved. Means the accused person who is taking the defense of unsoundness of mind, that is section 22, then his advocate has to prove that his client is unsound. And what more he has to prove? He is unsound. Because of that unsoundness of mind, he is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Therefore, sanity is presumed and insanity is to be proved. That is the first rule. The second rule is what? At the time of committing that act, the person must be suffering from insanity, not afterwards and all. Means after doing of the act, he became unsound, like that it should not be there. At the time of committing that offense, he should be unsound. Then only he can be exempted. And moreover, he should be medically examined. The accused person should be medically examined by experts, psychiatrists and all, and they have to, the panel of those experts have to see whether he is really unsound or not. They have to give their opinion. Thereafter, he will be considered to be unsound and he will be sent, the accused person will not be punished, he will be sent to asylum. The doctors who are going to check the person, his insanity and all, they should have meetings with that accused person, with that unsound, and then only they have to come to a conclusion. These rules are there which we follow now, and thereafter only the defense can be proved. Therefore, nothing is as per section 22, nothing is an offense which is done by a person who at the time of doing it, because of unsoundness of mind, is incapable of knowing the nature of the act or what he is doing, whether it is wrong or contrary to law. Then only he will be exempted. This concept under 22 is based upon one maxim, that is furosis furore sul punere, means madman is punished already by his madness, isn't it? Madman is punished already by his own madness, therefore he should be exempted. Now this is called as a legal insanity. Legal insanity is different and medical insanity is different. Medical insanity is a very vast concept. Medical persons are there to cure the unsound mind person, and therefore small things because of which a person's mind can be dearranged and all, in medical science they consider it as unsoundness. But in law, the lawyers or the jurists, they are there not to cure the unsound, they are there only to check whether whatever he has done, he should be exempted or not. Therefore, the concept of legal insanity is very short, it's very narrow. We only want that at the time of committing the offense, he was unsound. he was such a unsound that he does not know the nature of the act and the consequences of the act, and also whether it is right or wrong. That is legal insanity. One more famous case is there called as Lakshman Dagdu's case, which explains to us about medical insanity. Lakshman Dagdu was suffering from fever, high fever, for many days. So one day what happened, he wanted to sleep, and his children, they were not allowed, they were playing there, they were making very noise. Therefore he was not able to sleep. So what he did, he catched his both the children and he killed them, and after that took a very sound sleep. Thereafter he is taking the protection of unsoundness, stating that, see, how can a father kill a child? How can I kill? At that time I was not knowing what was I doing. I was unsound. Medical science may say that maybe at that time his mind is rearranged because he is suffering from such a high fever for so many days. But legal science says no. Such a kind of dearrangement does not allow a person to kill his own children. Therefore, nature of the act, consequences, and whether it is right or wrong, only that criteria we apply. And Lakshman Dagdu was punished. He didn't get the protection under section 22. Okay. Today we have seen two concepts. One is the position of a child in criminal law, and the second, the position of unsound mind. Nothing is an offense as per 20, 21 and also 22. Okay. Bye bye. See you in the next video.